Imagine owning land for decades. Maybe it's family land, passed down. Then a river slowly shifts, a neighbor builds something, and suddenly it feels like your property lines are just erased. You find yourself caught in this really complex legal fight over titles, over land that might even be public domain.
Right, yeah.
It makes you wonder, how do you actually protect your ownership when nature, questionable documents, and legal battles all collide? Welcome back to the Deep Dive. We're here to unpack complex topics, pull out the essential insights from the source material, and basically give you that shortcut to being genuinely well-informed. Today, we are diving into a really fascinating and I think highly significant Supreme Court case from the Philippines. It digs deep into land titles, riverbeds, property rights, all the tricky stuff.
It really is a fascinating case. It touches on so many layers: individual rights versus public interest, the integrity of the land title system, and it shows how even fundamental legal principles can get tangled up in the lower courts before reaching clarity. It's got some critical lessons.
Absolutely. So let's get specific. We're looking at the case of Aurora Tensuan, heirs of Dionysia Tensuan, heirs of Jose Tensuan, heirs of Leyda Tensuan, heirs of Francisco Tensuan, and Ricardo Tensuan, represented by Amparo S. Tensuan as attorney-in-fact petitioners, versus heirs of Ma, Isabel M. Vasquez, respondents. That's quite a mouthful, but the key reference for you is GR number 204992, and the decision date is September 08, 2020.
GR 204992. Got it.
Okay, let's paint the picture here. We have the Tensuan family. They owned a pretty substantial piece of land, about 32,862 square meters, in Poblacion, Muntinlupa City, and their ownership wasn't new. It was backed by a transfer certificate of title, TCT 16532, issued way back, January 7, 1950, so long-standing ownership.
Right, 50 years established, very clear on paper.
Their land was bordered by the Magdaong River, on the other side of the river. A property owned by Ma Isabel M. Vasquez, which she developed into something called Aguila Village. Now, the trouble starts brewing, it seems, in the early 1990s. Ma Isabel Vasquez decides to do some riprapping on her side of the river, the northern side.
Riprapping, that's basically reinforcing the riverbank, often with concrete or rocks, right?
Yeah.
Usually for erosion.
Exactly. But the Tensuans claim this wasn't just simple erosion control. They allege this construction work actually changed the natural flow of the Magdaong River, and crucially, caused the river to shift its course and start eating into their land. That was their core complaint initially.
Okay, so alleged encroachment due to construction changing the river's path.
Precisely. But then things got, well, stranger. A joint verification survey happens in April 1995, and it uncovers something really odd. This riprapping was apparently done based on a document called Special Work Order 13 Zawal 00271, supposedly from 1986.
A special work order. What exactly is that in this context?
Well, that becomes a huge point later. But according to the findings, this SWO, as they called it, seemed to cover not just the riverbank contour, but get this, part of the actual riverbed itself.
Covering the riverbed, that sounds problematic.
Extremely. And based on this SWO from 86, a whole new title, TCT 140017, was issued to Ma Isabel Vasquez on November 25, 1986. This new title magically added over 5,200 square meters to her property.
Wow, over 5,000 square meters appearing based on this order.
And here's the kicker. A significant chunk of that new area, 1,680.92 square meters, was actually part of the Tensuan's original titled land. An even larger chunk, over 3,500 square meters, was part of the Magdaong River itself, public land.
So the new title overlapped both the Tensuan's existing title and the public riverbed. That's audacious.
Right. And then Ma Isabel subdivided this newly titled, highly questionable area into 7 smaller derivative TCTs. So the Tensuans, understandably feeling their land was effectively stolen, filed a complaint. It was formally filed around late 1998, though initiated in 97. Their goal was clear. Get their land back, cancel that SWO, cancel TCT 14417 and all its spin-off titles, and make sure the Magdaong River was recognized as belonging to the state.
So you have this immediate conflict, right? The Tensuans saying, this is illegal encroachment, that title is completely void, it's based on nothing valid, and takes our land and public land. While the Vasquez side is arguing, no, the riprapping was just necessary maintenance, the SWO was legitimate. And they even tried to argue later that, well, maybe the river naturally gave them that extra land through accretion.
The accretion argument. We'll definitely get back to that. It set the stage for a real legal roller coaster through the lower courts. And what a ride it was. Let's walk through that because it's quite something. First stop, the Regional Trial Court, Branch 256. In September 2010, they ruled for the Tensuans.
So initially a win for the original owners.
Yes. The RTC declared that special work order null and void. They canceled TCT 140017, ordered the return of that 1,680 square meter chunk to the Tensuans, and awarded damages. The reasoning seems solid. The Magdaong River is public domain, you can't register it privately, and this SWO. Not a valid way to acquire land, plus its existence wasn't even properly proven, they said.
Sounds like a pretty clear application of basic property law principles. Public domain is public domain.
You'd think so. But then, hold on. Just 2 months later, November 2010, Isabel's heirs file a motion for reconsideration. And now they bring up two key arguments. This idea of accretion, the river adding land naturally and critically, they argue the Tensuans filed their case too late, that the cause of action had prescribed.
Prescription, the statute of limitations argument, basically saying you waited too long to sue.
Exactly. They argued TCT 144017 was issued way back in 1986, over 12 years before the complaint was filed. They framed it as an action based on an implied trust, which typically has a 10-year limit. And incredibly, the same RTC branch reversed itself. They dismissed the Tensuans case, they bought the prescription argument based on implied trust, and even said the SWO was presumed regularly issued.
Wow, a complete 180. That must have been devastating for the Tensuans, from winning to dismissed in 2 months by the same court.
Absolutely whiplash. So naturally, the Tensuans take it up to the Court of Appeals, the CA. In February 2012, the CA steps in, reverses the RTC's dismissal, and brings back that original RTC decision favoring the Tensuans. They even explicitly nullified the derivative titles.
Okay, so the CA put it back on track. What was their reasoning on prescription?
The CA said no, prescription hadn't set in. They saw the lawsuit differently. They said it was either an action for quieting of title, and since the Tensuans seemed to be in possession, that action is imprescriptible, meaning no time limit. Or they said it could be action revindicatoria, an action to recover property. And since the actual dispossession seemed to happen with the riprapping in the mid-90s, the case was filed within the 10-year period for that.
So the classification of the lawsuit itself became the crucial point for the prescription issue. Quieting of title versus implied trust.
Precisely. The CA also dismissed the accretion claim as being raised too late and found the SWO wasn't proven. Things look good again for the Tensuans, but, you guessed it, another reversal. In July 2012, the same division of the Court of Appeals granted a motion for reconsideration from the Vasquez heirs.
Seriously, the CA reversed itself too.
Yes, they flipped again, reversing their own February decision and affirming the RTC's dismissal. Now, the CA decided the Tensuans hadn't proven possession sufficiently, so they went back to classifying it as an action for reconveyance based on implied trust, which they ruled again had prescribed. They even cast doubt on the survey reports that showed the overlap.
Unbelievable. This back and forth it really highlights the confusion, doesn't it? How difficult it can be even for appellate courts to pin down the exact nature of a claim and apply these fundamental concepts like possession and prescription consistently. That distinction between quieting of title, which hinges on possession for imprescriptibility, and reconveyance based on implied trust with its 10-year limit, it was everything here. Getting that classification wrong basically shut the door on the Tensuans multiple times.
It's just extraordinary. Winning, losing, winning, losing.
Yeah.
All based on these shifting legal interpretations. So after all that confusion in the lower courts, the case finally lands at the Supreme Court. What did the highest court in the Philippines have to say about this tangled mess? How did they finally resolve this battle?
Well, the Supreme Court thankfully brought a lot of clarity. They tackled the key issues systematically and really laid down the law, reaffirming some very basic but critical principles. Let's break down their analysis. First, that huge threshold question. Has the action prescribed? Did the Tensuans wait too long? The Supreme Court's answer was a clear and resounding no. It has not prescribed.
Okay, how did they get there, cutting through the lower court's confusion?
They looked at the substance, not just the label, of the Tensuans' complaint, and they determined it was, in essence, an action for quieting of title under Article 476 of the Civil Code. Remember, for quieting of title, you need two things. 1, a legal or equitable title to the property, and 2, some deed, claim, or proceeding that casts a cloud over that title.
And the Tensuans had both.
Definitely. They had the legal title through inheritance, backed by their 1950 TCT 16532, and that later TCT 144017 issued to Vasquez clearly constituted a cloud since it overlapped their land and public domain land. But the absolutely crucial finding by the Supreme Court was that the Tensuans were in possession of the property they were claiming.
Possession. That's the key for imprescriptibility in quieting of title, right?
Exactly. Because they were found to be in possession, their action to quiet title was imprescriptible, meaning it could be filed at any time. The whole 10-year implied trust argument just didn't apply to the actual nature of their claim and their situation. The SC noted they didn't sleep on their rights. They acted pretty promptly once the encroachment became clear in the mid-90s, reporting the rip-wrapping, seeking that verification survey in 1995.
So that finding on possession completely dismantled the prescription defense that had caused so much back and forth.
Completely. It was the cornerstone of resolving that issue. It basically means if you own land and you're actually using it or holding it, and someone comes along with a dodgy claim or title casting doubt on yours, you don't lose your right to clear that cloud just because time has passed.
Okay, issue 1 resolved. No prescription. What was the next big question for the Supreme Court?
The next logical question was, all right, even if the case can proceed, was TCT number 140017, that title issued to Vasquez in 1986, based on the SWO validly issued in the first place? And again, the Supreme Court's answer was a very firm NO. They declared it void ab initio void from the very beginning.
Void from the start. Why? What were the grounds?
They laid out 3 main reasons, all quite fundamental. First, the prior registrant rule. This is huge in the Torrens system. The Tensuan's title, TCT 16532, was registered in 1950. Vasquez's TCT 14017 came much later in 1986. When 2 titles overlap the same land, the rule is simple. The earlier valid registration prevails.
So the system protects the first person to register properly.
Precisely. Vasquez was legally considered to have constructive notice. She should have known that the 1,680 square meter portion already belonged to the Tensuans under their prior valid title. You can't just get a later title over land already titled to someone else.
Makes sense. What was the second reason for voiding the title?
This goes back to that mysterious document, the special work order fallacy. The court looked at the basis for TCT 14017, which was solely that SWO 1300000701. And they stated unequivocally that a special work order is just what it sounds like, maybe a permit for work, maybe a survey reference. It is not a recognized way to acquire ownership of land under the Civil Code.
So you can't get a land title based only on a work permit?
Absolutely not. The court even cited a DNR memorandum circular confirming that SWOs cannot be a subject of titling. Ownership comes through things like law, donation, succession, contracts, prescription, not a construction permit. So the very foundation of TCT 144017 was invalid.
Okay, prior registration invalid basis. What was the third reason?
A third reason was the public dominion violation. This was about the other part of the land covered by TCT 144017, that huge chunk of over 3,500 square meters. The surveys clearly showed this was part of the Magdaong River bed. And the Supreme Court reiterated a bedrock principle. Rivers like seas, shores, etc. are property of public dominion under Articles 420 and 502 of the Civil Code.
Meaning they belong to the state for everyone's use.
Exactly. They are outside the commerce of man. You simply cannot acquire private ownership over them. You can't title a riverbed. So TCT 144017 was void not only for overlapping the Tensuan's private land, but also for attempting to privatize public land.
Wow. So multiple fundamental reasons why that 1986 title was just completely invalid from the get-go.
Absolutely. It violated prior rights, it was based on an improper document, and it illegally included public land, a trifecta of invalidity.
Okay, that seems very clear. What about that other argument the Vasquez heirs raised accretion? Did the Supreme Court address whether the river might have naturally added land to the Vasquez property?
They did address it, but primarily on procedural grounds and basic principles. The ruling on accretion was also NO. First, the court noted the argument was raised improperly late, only during the motion for reconsideration at the trial court level. This violated the Tensuan's right to due process, as they didn't have a fair chance to address it earlier.
So you can't just bring major new arguments late in the game.
Generally, no. But beyond that, the court hinted that accretion, which is the gradual deposit of soil by a river, wouldn't apply anyway to land that was already part of the public domain riverbed. You can't accrete public land into private ownership like that. Plus, they stated that whether accretion actually happened here was a question of fact, and the Supreme Court isn't typically the place to re-examine factual findings unless there are compelling reasons, which they didn't see here.
So the accretion argument failed, both procedurally and on principle. That's a really thorough dismantling of the Vasquez claims by the Supreme Court. So the final verdict came down clearly in favor of the Tensuan family, right?
Yeah.
Shed so much light on these core land ownership principles.
Yes, the judgment was decisive.
Let's recap the ultimate outcome then. The Supreme Court granted the Tensuan's petition. They reversed those problematic Court of Appeals resolutions that had dismissed the case. And importantly, they reinstated the CA's earlier decision from February 24, 2012, the one that had originally sided with the Tensuans, and upheld the initial trial court ruling.
Back to the first correct ruling, essentially.
Exactly. Which meant TCT 144017 and all its derivative titles were definitively declared void, wiped off the books. And there were specific orders for the Vasquez heirs, too, weren't there? It wasn't just about the titles.
That's right. They were explicitly ordered to restore to the Tensuan petitioners that 1,680.92 square meter portion of land that had been wrongly included in their void title. Give the land back. And they were also ordered to pay damages and cost P $50,000 for acceptance fees, P $1,500 for appearance fees, and P $100,000 for attorney's fees, plus interest.
So, real consequences. And you mentioned earlier this concept of builder in bad faith. How did that play out in the final orders?
Yes, that was a significant finding. The Supreme Court deemed Ma Isabel Vasquez a builder in bad faith. Why? Because she built structures based on a title derived from a mere construction permit, the SWO. She ignored the Tensuan's notices about the encroachment, and she knowingly included public riverbed land in her title claim. These actions showed bad faith.
And what does being a builder in bad faith mean legally under the Civil Code?
Under Article 449, it means she loses whatever was built or planted on the Tensuan's 1,680.92 square meter land without any right to be compensated for it, no indemnity. And Article 450 then gives the landowner, the Tensuans here, options. They could demand the demolition of the structures at the builder's expense, or they could choose to compel the builder, or her heirs, to pay the price of the land occupied by the structures.
So the Tensuans get to choose how to deal with whatever was built on their restored land.
Correct. They were directed to inform the trial court which option they chose. It really underscores the risk you take when you build on land you don't rightfully own, especially if you know or should know it's improper.
And finally, what about the river itself, that large portion included in the void title?
The Supreme Court was explicit. The remaining 3,556.62 square meters, identified as part of the Magdaong River, were formally declared to belong to the state, reinforcing that public domain status.
Okay, this case went through so many twists, but the Supreme Court's decision really crystallizes some vital legal doctrines. These aren't just abstract concepts. They have real-world impact, especially when you're dealing with property near water. Let's quickly recap those key takeaways for our listeners.
Absolutely. It's worth highlighting the core principles this case powerfully affirmed. First, the action for quieting of title under Article 476. The big takeaway. If you, the plaintiff, are in actual possession of the property, this action to clear any cloud on your title is imprescriptible. No statute of limitations. Possession is key.
So, stay on your land, use your land, and you preserve your right to defend your title indefinitely.
Essentially, yes.
Right.
Second, the prior registrant rule under the Torrens system. This is fundamental to land registration stability in the Philippines. The first validly registered title prevails over later overlapping titles. Due diligence on title history is non-negotiable for buyers.
Check that history. The oldest valid title wins.
Got it. Third, the absolute nature of property of public dominion, Articles 420 and 502. Rivers, shores, and similar natural resources belong to the state, are for public use, and simply cannot be privately owned or titled. Any title claiming them is void.
Public resources stay public, a crucial environmental and social principle.
Fourth, the court clarified the nature of a special work order. Remember this, an SWO is, at best, a survey reference or construction permit. It is not a mode of acquiring ownership and cannot be the basis for a land title. Don't be fooled by official-sounding documents that aren't actual deeds or recognized legal grounds for ownership.
A permit is an ownership. Simple but vital.
And finally, the consequences of being a builder in bad faith, Articles 449 and 450. If you build on someone else's land or on public land knowing it's wrong, you lose what you built without compensation. And the rightful owner gets clear options, like demanding removal or payment for the land. It's a strong deterrent.
Those are really clear, practical takeaways from such a complex case. It makes you think. Considering how tricky boundaries can be, especially near rivers that might shift naturally or otherwise, what practical steps can property owners take? To proactively guard against these kinds of encroachments or legal nightmares? That's a great question for everyone listening to ponder. We'd love to hear your thoughts on that or anything else that stood out to you from this deep dive into Tensuan v. Vasquez. Drop your comments, insights, maybe what surprised you most, wherever you're listening, or find us on social media.
A final thought to leave with you. This case is such a powerful illustration that while a land title, a TCT, is a very strong shield, It's not automatically impenetrable. Its strength, its validity, ultimately depends on the legality of how it was issued, especially when it bumps up against public resources or, like here, pre-existing valid private claims. It's a reminder for everyone to perhaps question that prima facie or surface appearance of validity sometimes and really dig deeper into the origins of a claim if something feels off.
That's a fantastic point. Always dig deeper. Well, if you found this deep dive valuable for getting your head around the complexities of Philippine land law, the Torrens system, and why due diligence is so critical, please make sure you hit that subscribe button. Don't miss out on more shortcuts to being truly well-informed right here on The Deep Dive.